We are here for a circuit court session devoted to motion hearings. And as is customary, let me ask if there's any counsel that has a conflicting court appearance and needs to be called earlier. Anybody fall into that category? Please speak up.
Matthew Hyder.
All right, hello,
I
Mr.
have
Hyder.
3 different court appearances this morning. If you'd take me, I'd much appreciate it.
Sure. Which case do you have?
I have Manuel Serrano. It's actually 2 cases. It's 19 CF 2029 and 19 CF 2042. We're actually here for a competency status.
All right. And Mr. Maresca for the state, I see, is connected.
Yes, Judge.
All right. And any comments from the defense?
Your Honor, I'm going to end up sounding like a broken record. We set this for a status because we've put in a request to the hospital to get Mr. Serrano's records from a previous head injury that has been described as a TBI, a traumatic brain injury. We put those requests in about, I think at this point it's running up on 2 months. About every other week, we call to check on the status of those records because we haven't received them yet. And we have been told multiple times that they're backed up quite a bit from COVID. And in fact, they tell us not to reach back out to them, but we still do, obviously, because this is incredibly important. That being said, I am going to request additional time because I do believe these records are important. But I also didn't want to, hide the ball. It has been ongoing for a while. It's just they appear to be very, very backed up.
From what I see, Dr. Nelson, I believe, in January found him not competent or recommended such, and Dr. Arias in February recommended not competent. Obviously, we now have a problem that those reports may be growing stale. What is the purpose of the record gathering?
So what we had previously discussed is in I believe Dr. Nelson's evaluation, there was no mention of this injury. It's something that myself and my partner have been aware of. But then when Dr. Arias did his evaluation, Mr. Serrano mentioned this traumatic brain injury that occurred, I believe, a couple years ago when he fell off a riding lawnmower. Mr. Maresca had expressed an interest in seeing those records. And I think the belief that, I don't want to speak for him, but I think the belief is that would go towards, their evaluation and potentially the concept of permanency, in my opinion.
Now, are we able to determine competency separate from the records, or is that part of the competency analysis?
I don't believe that. I believe competency can be determined without the records. Like as the courts noted, there's 2 reports where the professional evaluators have indicated that he's not competent. I believe if we were to go to a hearing, the court, could rely on those reports, that the testimony that would be taken at a hearing, and make a determination as to competency. The one issue that would potentially remain is if the incompetence is based on a traumatic brain injury, I think that could affect the evaluator's opinion as to whether it's permanent or something that's restorable.
Mr. Maresca, any thoughts?
Judge, my memory is that the one doctor who found him incompetent was based upon his self-reported this injury. And quite frankly, if I remember correctly, he indicated if there's no basis for that, then maybe his opinion would change. I think it's very important to get these records, if they exist, to either document or corroborate the expert's opinion or not.
Does the defense believe that it would be necessary to have a court order for release of the records?
Your Honor, we had previously addressed this. I think that, unfortunately, I don't know that the court has the lawful authority to issue such an order in this circumstance. It would make things a lot more convenient. I'd love to be able to tell the court yes, but I don't know that the authority exists. And also, the people that we're speaking to claim to be working as hard as they can to get us these records. It's just taking a long time. Like I said, they're telling us it's due to being backed up from COVID and employment shortages.
So are these records being subpoenaed by the defense? Is that what's occurring?
They're not being subpoenaed. We sent a records request in but it's not a subpoena, Your Honor. And I can't find the authority to subpoena the medical records for a competency hearing.
Mr. Maresca, what about that?
Well, I would think the defendant, it's his medical records. If he signed a release, they have a responsibility to release them, in my
And he
opinion.
has.
Have they given you any time frame?
Your Honor, they have given me a time frame, but they've previously given time frames that have not been met. So I'm cautious to place too much hope. We were told last week that it would be 2 weeks, but we were told a month ago that it would be 2 weeks as well.
Is the state seeking any additional evaluations?
Well, Judge, we probably will, but first we need to know if these records exist. Because if they don't exist, I think one of the, I thought it was Dr. Arias said he might have a different opinion.
At this point, Mr. Hyder, you're closest to it. What do you suggest?
Your Honor, I would ask for more time to get these records. Like I said, I just wanted to be open and completely candid with the court that I know it's taking a while, but I can assure you that we are doing everything that we can on our part to try to get them in a timely manner. But
well, there must be, especially with the defendant agreeing to release his records, I have to believe that if they are affecting a court determination of competency, that there has to be a process whereby the court can order compliance with the subpoena ducis tecum or something, but we'll give it one last opportunity. In the meantime, Mr. Maresca, I think we're going to have the evaluators update their reports, because I think by the time we reach the competency hearing, they will be stale.
That's fine, Judge, if the court thinks that's appropriate.
So, Mr. Hyder, let's set this for a competency status review, status only, in about another 30 days.
that's fine, Your Honor. And for what it's worth, Mr. Maresca, if you are aware of some authority, or if the court is aware of some authority that would allow a subpoena ducis tecum to be issued, I believe that would make all of our lives easier. I'm certainly not opposed to that if the authority exists.
Well, I think you could do a subpoena ducis tecum. I don't think it's appropriate for me, since it's your client, because I'd have to get him to sign a notice to release the records. And then if they don't fulfill the requirements in a timely manner, the court can, make them appear and explain why they're not fulfilling the subpoena ducis tecum. I think that'd be the best way to do it, actually.
How long has this been going on, Mr. Hyder, since you made the initial request?
I think it's running up on 2 months now, Your Honor.
All right, let's give it another 30 days. Perhaps you can tell them that the court may need to get involved if they don't produce it within that time frame. We'll come back. I'm thinking when we come back, I'll probably I don't want to order the evaluations updated yet, because I think they're going to need to consider that information. So,
Yes, Your Honor.
Ms. Fuentes, if you could just make a note and inform Melissa that at the next status review date, which we'll set now, we'll address the records issue as well as updating the evaluations.
It sounds good, Your Honor. Thank you.
And Ms. Fuentes, what would be the recommended competency status review? We'd only need 10 minutes on that, just for an update.
I don't have those dates, Your Honor, but I can get them.
All right. I do want to set it from here. I think this is one of those where I'll need to call Melissa. Okay, while we're waiting, there's also an ICE hold, if Mr. Hyder, if you were not aware of that. So the record will reflect there is an ICE hold in the defendant's case, Madam Clerk. Melissa, Madeline was telling me that she does not have a date for a competency status review. Are you providing those?
Sure.
So about 30 days out, it's on the Serrano case. All we need is 10 minutes. There is some discussion, but it's just the status. So one moment. And while we wait for that, the next case I call will be the State versus Russo case. That's with Attorney Benjamin and Mr. Ashby. I do have a motion on that.
No, okay. So.
Would July 12th at 9 o'clock be okay?
Is that acceptable side, July 12, 9 a.m.?
That's fine, Judge.
Yes, Your Honor, that's fine with us as well.
It is set. Thank
And
you.
which case is that?
Serrano,
Okay.
2 cases. All right.
19 CF 2029, 19 CF 2042.
Any
Thank
others,
you.
Mr. Hyder?
That's it, Your Honor. Thank you very much for taking me first. Have a great day, everyone.
Very well. Next is the Russo case, 21 CF 63. Attorney Benjamin and Mr. Assistant State Attorney Ashby is Mr. Yeah, I see Mr. Ashby there. Is Mr. Benjamin or co-counsel appearing?
Yeah, Judge, good morning. Peter Patanzo, I'm Mr. Benjamin's law partner. I know he filed a motion to continue, which I think was given to you this morning.
Yes, I do have that in front of me. There are health issues that are affecting the case. Mr. Ashby, any objection to continuing this matter?
It's Brock Frazier for the state, Your Honor.
Yes, Mr. Frazier.
Given the circumstances, there's no objection. There is an amended information that was filed. The defendant does need to be arraigned on that. I don't know if counsel today is able to waive arraignment or if we need to address that at the next court date.
I think we can file written pleadings or we can waive the arraignment. That's not a problem. I just need a copy of the amended information if that could be emailed to us.
Hey, Mr. Frazier, what's the nature of the amendment?
There are three additional one charge was null pros for no lab result, and there were three additional charges for trafficking in various controlled substances.
All right, so it is a substantial amendment. Is a plea of not guilty being entered orally at this time by defense counsel?
Judge, before we do that, can I have an opportunity to see the amendments? Can I have an opportunity to see the information? I haven't seen it yet.
Okay. We would just need, are we going to set this for a new arraignment date, Mr. Frazier, at this point, or what do you suggest?
Well, Your Honor, I think that we can accomplish that at the next hearing date, or in the interim, if counsel wishes, they can file a written plea.
All right, so I'll set it for a combination arraignment and case management. Mr. Patanzo, when will defense counsel be available?
I'll stand in for Mr. Benjamin. I don't think he's going to be prepared in the next 2 weeks, but I imagine you'd like to do it within 2 weeks. So,
is there a waiver of speedy trial?
not until I see the amendments.
Okay. What's the next case management day, Ms. Fuentes?
We would be looking August 19th,
Anything before then?
July 15th at 1:30 or June 10th at 1:30.
Any objection to the July date, Mr. Frazier? Or do you wish to have the June one since speedy is not waived?
The state would prefer the June cycle at this point.
Very well. Then again, the June date and time, Ms. Fuentes?
June 10th at 1:30.
So the defense motion to continue is granted. Arraignment and case management are both continued to that date. Counsel may appear remotely.
Thank you very much, Judge.
All right, thank you. Again, any other counsel that has a conflicting court appearance that I need to call next? Please.
Judge, this is James Lewis in Fort Lauderdale. I do. May I call a case, please?
Yes, hello, Mr. Lewis. Which case do you have?
Torina Cypress with Mr. Maresca.
19 CF 2298, Mr. Maresca for the state.
Judge, I had originally filed a motion to surrender on a violation of probation. She was out of custody and the warrant was issued. As luck would have it, she got arrested on a traffic stop over in Hendry County. She is now in custody in the Collier County Jail. She called me from the jail. I guess they didn't bring her over or she's not available on video. We've been talking about trying to resolve the case. Mr. Maresca tells me she scores 12.45 months in the bottom and is offered a year in the county jail, and that's the recommendation of probation. Though I'm asking for a little better, Judge, I'm going to be asking you consider it a community control sanction. So I guess maybe we could set it for the next available date. We'll probably plead open to the court and see what we can do.
I will, when is our next probation hearing date, Ms. Fuentes? Ms. Fuentes, are you still there? I think she just appeared for the case management. Let me take a look at our calendar. One moment. All right, it would appear that we have a June 9 date, it looks like. Would the state be able to be ready for a plea to the bench on 1:30 on June 9, Mr. Maresca?
For a plea to the bench, probably, Judge.
This would not be a full hearing, is that right, Mr. Lewis, that he puts to the bench if it goes?
No, Judge, I don't think it's going to take a lot of time. Unfortunately, though, I have a murder case in Orlando on that same date. Would you have any sooner time, Judge, than June 9th?
The only time is this Wednesday. The
That being the 19th?
Right, at 1:30, but I don't know if the state can be prepared by that time.
Judge,
Judge,
it's
on
not a,
Wednesday, somebody's going to have to cover for me, so I'd rather the June 9th or sometime after that.
All right, it'll have to be then the June 9 date. Now, if council is trying to set a bond hearing, that can be coordinated with my office and probably heard sooner than then, but it would have to be coordinated with the state and my office. But
okay.
the state does not oppose the June 9, 1:30 setting, Mr. Maresco?
No, but I think counsel indicated he's not available that day.
Well, I have a murder trial in that morning in Orlando, but I'm not a murder trial, but a murder hearing. Could I appear virtually? Would the court allow me to appear virtually for that kind of a hearing, an open plea?
I think that will be difficult.
Okay.
I think that would need you to be in person for that full season.
Then could I ask for an alternative date, Judge?
Yeah,
other
let me
than
take a look. It would be June 23 at 1:30. Again, if the issue is her status in custody, you can also set a bond hearing sooner with coordination of my office and Mr. Maresca.
That's fine. June 23rd at 1:30 looks good, Judge. If I could have that date.
Clarification, Mr. Lewis, this would not be a full hearing. It would either be a plea to the bench or a plea agreement. Is that correct?
Correct, Judge. It will definitely not be an evidentiary hearing. It's a plea to the bench, or I'm going to talk to Mr. Carrasco.
It can be an evidentiary hearing, but the state just needs to know if they need to prepare for the full hearing or just for a plea to the bench. And it sounds like it should be either a plea to the bench or plea agreement.
Just a plea to the bench, Judge. We're not contesting it. It's a dirty urine for Xanax. We're not contesting the violation. It's just a question of what the appropriate sentence might be.
Very well. It is set. Thank you.
Thank you, Judge.
Any other counsel that has a conflict? Mr. Russo?
Yes. Good morning. I have a case with Judge Brown at 9 o'clock for non-jury trial. Here with Your Honor, I have Anthony Spinella, case number 21CF602 with Mr. Maresca.
Very well. This is a motion to modify bond conditions. Does the state oppose this?
Judge, we oppose it, and we also opposing it beyond the 5-minute jack docket because the defense is asking to take testimony, and obviously we can't be in the courtroom to give direct or cross-examination of any testimony. So I don't think this is an appropriate motion to be on this docket.
That would appear to be correct, Mr. Russo. Typically, we do not have the bond hearings on this particular docket. Any comments?
Well, the comment is I do have the alleged victim present to give testimony. So if it's not appropriate, we'll have to reset it. But the defense is ready to go forward. But as Mr. Maresca pointed out, these are evidentiary. I do have a witness here, the alleged victim.
Okay. Is that right, Mr. Maresca, going forward in this format? Is that correct?
Yes, Judge. We want the person to be, in court, subject to direct and cross-examination.
Okay. So that objection is sustained. If you'll inform my assistant, Mr. Russo, that we'll try to accommodate this as soon as it can be fit in with both you and the state.
Yes, sir.
In the court's calendar. So that'll need to be rescheduled then, but Ms. Fuentes, well, we've lost her. So if you can just tell my assistant that I did say we would try to fit it in as quickly as we can.
Okay, thank you.
All right. Any other counsel that has a time conflict of any kind that I need to address? All right, if not, let me go from the top. The Alexis case, 19 CF 2205, Mr. Khalil for the defense. I'm not sure who is for the state. It's a competency status.
Ryan Asher on behalf of the state, Your Honor.
All right, Mr. Ashby, all right. Mr. Khalil.
Your Honor, we're having a bit of a deja vu in the office. Our systems are down. I believe this is a competency as well.
The hackers are at it again?
We hope not, Your Honor. We hope
Is
not.
it Russia or some other country again?
Undetermined. So I'm not sure if a report has come out this morning, but I did speak to the doctor last week. She was in the final stages of having her report available. We'll just be asking for the next competency status date unless the court has received that competency report.
I don't show that I have. We appointed Dr. Nelson April 1. I did not see any thing entered in the electronic record current that shows it's been received. I've not been informed by my assistant that we have it.
He is out of custody, so we
You sound like you're broadcasting from Mars, Mr. Khalil.
For the next competency status date. Your Honor, we'll just be asking for the next competency date. He is out of custody, so it's
Okay, let me see if I can provide you that date now.
That's Ryan Leach's office.
Melissa, clarification, please, for these competency status continued dates. How did you want to handle those? Were they to be set in court through you or otherwise?
You can set them in court through me.
All right, so we need one for Alexis, 19 CF 2205. How many days out, Mr. Khalil?
Your Honor, the next available, a week or two, we'll defer to the court. It seemed that when I spoke to her last that it should be fairly quick.
So within the next 30 days, Melissa?
June 7th at 9 o'clock or July 12th at 9.
Is there a preference, June 7th or July 12th?
The June 7th, Your Honor, should work.
Any objection, Mr. Ashby?
No, Your Honor.
So Melissa, June 7th at what time?
9 o'clock.
9 o'clock. Continued status review on competency.
Thank you, Your Honor.
Next is the Bowie case, 19 CF 1248. Ms. Wilson listed for the state and Mr. Hill for the defense.
Good morning, Your Honor.
Greetings, and Mr. Bowie actually has an also known as Darnell Hill, I believe. No, not Hill. I don't have, what's the other also known as? It's Mark Darrell Holland. Mark Darrell Holland, okay.
Right.
Yes, Mr.
Yes, sir. Good morning, Your Honor. Your Honor, I don't know if you had an opportunity to see the Dr. Collins report yet, but he was found incompetent to proceed. And based on the fact, I don't know if Ms. Wilson had an opportunity to speak with the state on the related case, which is where he is actually a victim of an assault at the jail. I took liberty to file a motion to ask the court to release him to his mother. Of course, one of the big concerns that I have is that he may, continue to be victimized, and apparently having been found incompetent to proceed. I'm not a learned counsel on mental health. However, I've had this situation before, and I have concern about him again continuing to be victimized, Your Honor. And this was a pretty serious assault, Your Honor.
Was that motion set for hearing today, Ms. Wilson?
No, it was not, Your Honor.
Okay. We do have the competency status review. Apparently, Mr. Hill is correct that the defendant has been recommended to be found not competent by Dr. Collins. Is the state requesting a second evaluation?
No, Your Honor, the state be willing to stipulate to the court making a finding in regards to competency based on the report of Dr. Collins.
Mr. Hill, does the defense wish to stipulate to the report and to the court making a decision based on the report?
Yeah, yes, Your Honor. Yes, Your Honor. Thank you.
And is the defense recommending a finding of not competent based on the report?
Yeah, yes, not a finding that he is found to be not competent to proceed, Your Honor. Yes.
And is the state arguing to the contrary or accepting the recommendation?
We're accepting the recommendation, Your Honor.
All right. With regard then, I will go ahead and treat this as the stipulated competency hearing based on the report. I will enter a written order to that effect to follow. With regard to the issue of the motion for release, that will need to be set, Mr. Hill, in the interim. Does the report, I believe the report recommends that he be treated in the community, is that correct?
That was my understanding from reading it, Your Honor.
Okay. So we will need to set it. Does the state dispute that?
Your Honor, the report states that the defendant will require competency restoration under the care of medical professionals in a community setting, which of course could take place in the jail also. But they're not recommended that he be sent away to the state hospital or anywhere for competency restoration.
Well, it would appear then the court needs to enter its order. I'll ask Mr. Hill to coordinate with my office and with Ms. Wilson for the motion for release pending competency restoration.
Yes, Your Honor.
All right. So I'll enter the order separately and counsel to set the motion hearing.
Yes, Your Honor.
All right. Anything else on this for today?
Not today, Your Honor. Not from defense.
Very well. Thank you.
Thank you. May I be excused, Your Honor?
Yes. Have a good day.
You as well, Your Honor. Thank you.
Next is Calumella, 20 CF 1228, motion for early termination, supervision, Mr. Hopkins and Ms. Wilson. Does the state object?
Your Honor, I did get a hold of the state probation officer, Holton, and he said that that he has completed all special conditions of probation. He has no violations of supervision, and he's paid off and is current with all his monetary obligations, and that he is eligible for early termination of probation at this time.
Mr. Hopkins, any clarifications?
No, Your Honor.
Based on the state's comments and the motion, as well as the review of the court file, the court approves the motion. Mr. Hopkins to provide an order terminating supervision.
Yes, Your Honor. Thank you.
Thank you. The Hager case, 21 CF 433, Ms. Wilson and Mr. Day, motion for evaluation. Any appearance by Mr. Day or colleague? Don't see anyone right now at this time. I'll recall that matter. Jackson, 6 CF 1024, Mr. Ashby and Mr. Hopkins. Nope, I'm sorry. Well, yes, Mr. Hopkins, but Michael Eric Hopkins. Yeah, that's Mr. Hopkins, all right.
That is.
The middle name threw me off.
Throws me off sometimes too.
Okay. Does the state have any comment on this?
State has no objections to motion to seal, Your Honor.
And let me take a look. Mr. Hopkins, any clarification?
Your Honor, there's a certificate of eligibility that you'll see in the requisite documents. The check has been submitted to the clerk for the $42. It hasn't been processed yet, showing in showcase. So I recognize that until that gets sorted out, there will be no sealing. And I've also been advised this morning, there's an additional monetary amount that was due. Apparently years ago, Ms. Jackson had the public defender and she never paid the public defender fee. So I recognize that'll have to be addressed as well, and I'll discuss that with her.
Okay, so at this point, I'll grant it contingent upon those payments being made and defense to provide an order.
Yes, Your Honor.
Any clarification needed from the clerk?
No, Your Honor, thank you.
So approved conditioned upon the payments. That brings us up to Touchard, motion for early termination of supervision. Again, Mr. Day's firm. I don't see anyone connected yet on Mr. Day's firm as in the previous, so I'll recall that matter. Kegel, 17 CF 1746, motion for early termination of supervision. Mr. Ashby and Mr. Ward, any state objection?
No objection.
Taking a look at Kegel, one moment. Any clarification from the defense?
No, Your Honor. She was placed on 5 years probation back in October of 2017. So she's over the halfway point now. She's paid everything. Probation has no objection.
And she did pay restitution in the amount of almost $12,000.
Yes, Your Honor.
Okay. The only pause, she's 19 years old. I assume, Mr. Ashby, there was no significant criminal history.
No, Your Honor.
Okay, this was a breach of trust, employee theft. I give the defendant credit for paying a large restitution amount. My only partial concern was that according to the probable cause affidavit on the in-store video, after they were seen removing the cash and stuffing into their pockets, the two defendants then began dancing and high-fiving each other for their achievement. However, with the passage of time, it appears that things have been righted and corrected, and I think Ms. Kegel does deserve credit for that. She's made the effort, and there's no significant history. So even though it was a breach of trust and a bit aggravated, I think that she's earned the early termination. So well done, and it is granted. And Mr. Ward, to provide an order.
Yes, Your Honor. As soon as we get our internet back, I will email one to your JA.
Okay, very good. Next is State v. Elkins. Motion to direct electronic court reporting to disclose court mark disc from an injunction hearing. That's also Mr. Day's firm. I don't see him connected yet.
Public defender.
I'll recall that. And next up is Perez, Ms. Wilson, and Mr. Clark, 19 CF 1868, motion for early termination of supervision. Ms. Wilson, any objection?
Your Honor, I did get a hold of the victim law enforcement officer, and he says he has no objection to the early termination. I spoke to the probation officer, Skidmore, and he said that the probationer is up to date on all of his payments and has completed his conditions, and he supported the motion.
Any clarification, Mr. Clark?
No, Judge, just that Mr. Perez has completed half of the 18 months that he was sentenced to. He completed the anger management and the substance abuse evaluation that was required even before he was placed on the probation. He has made the payments. He's been very, I guess, cooperative with the probation officer as he's indicated. So we would ask that it be terminated.
This was somewhat aggravated. The officer was bitten, but apparently it did not cause any significant injury or break the skin. There's no known objection. Is that correct, Ms. Wilson?
That's correct, Your Honor.
Granted. Defense to provide order.
I'll do that today, Judge. Thank you.
Very well. Next we have, well, let me see who Mr. Gorman has now joined us. Hello, Mr. Gorman, can you hear me?
Yes, Judge Thomas Gorman from Law Style Day. How you doing today?
Greetings. Gorman, we have 3 matters that we previously called. We can take them now. Beginning with Hager, this is a motion for evaluation. Any comments?
Yes, Judge.
We're not getting your transmission, Mr. Gorman.
Correct, Judge. We have competency and we would just ask.
Mr. Gorman, we're having difficulty hearing you. It looks like you may be in the courthouse. Is that correct?
That's correct, Judge.
All right, let's take a 5-minute break. If you want to walk into the courtroom, it's in 2B, and then that way we'll get over the problem with the transmission, and then we'll pick up from there. 5-minute break.
Thank you, Judge.
Okay. Mr. Hollander, are you able to hear me?
Yes, sir.
Which case do you have?
I'm here on Baker, 20 CF.
Motion to early terminate. Ms.
Yes, sir.
Mason, are you connected? I had taken a brief break, so people may be getting back to their place.
That's right, because I have a conflict, so.
Hello, Ms. Mason. You'll just need to unmute Ms. Mason. We can't hear you.
Oh, we're doing it right now.
Waiting for Ms. Mason to connect.
I think she's unmuted.
I am unmuted.
Oh, there we go.
Maybe
Oh,
just
okay.
a volume issue. Okay, so it was not a muting issue, it was a volume issue. Okay, all varieties. All right, Baker is 20 CF 353. Motion to early terminate supervision. Does the state have opposition?
Yes, Your Honor, we do.
All right, Mr. Hollander, your argument?
He's done everything he was supposed to, Judge.
Your Honor, I apologize. It's not this one. I couldn't, my writing spilled from another one. The state does not have any objection to this, Your Honor. He has completed 8 out of 12 months of his probation and with no violations, and he's fully paid.
Yeah, Mr. Hollander looked a little perplexed for a moment there. But,
Sorry.
That's just my Monday morning look, Judge.
okay. It's all of our looks. But, all right. No, it appears based on the motion that he has done what's been expected early. Motion is granted. Defense to submit an order.
We will do so, Judge, today.
Any others, Mr. Hollander?
No, sir. Thank you.
All right. Still waiting for Mr. Gorman, I think. Yep. All right. Let me go on. I saw Mr. Nagel and Mr. Ward. Mr. Nagel, what do you have?
I'm on the 10 o'clock docket, Judge.
That's
I jumped in early. Mr. Ashby, around, we can call it now. The Turner.
Go ahead. Yeah, Turner. Yes, 19 CF 1156 and 11 CF 2428. Competency status, Mr. Ashby for the state.
Yeah, Judge, the court received the packet from the Department of Children and Families where Ms. Turner had been sent for competency restoration, saying that she is now competent to proceed. She has been transported here to Collier County at this time. I have spoken to her both at the hospital recently as well as while she is at the jail, and I believe that she is competent to proceed at this time on the matter.
Okay,
So
did both of, is it just, it's the one facility evaluation, is that
yes,
correct?
this one was already found incompetent and committed, so now they only do the one report.
Does the state wish to request a competency hearing, or is the state willing to agree to have the decision based on the report?
State can stipulate to the report for the court review to make a determination.
And the defense is asking for a finding of competency?
Yes, Judge, I believe that the court can rely on the doctor's reports from the facility,
okay,
as well as the stipulation by both parties, and that should be sufficient as long as the court puts those findings into the record.
So I will do an order to that effect. I'll ask Mr. Nagel to submit a proposed order on it. Any future scheduling to be done?
Judge, we're looking, based on the totality of the circumstances, Ms. Turner has been in custody almost 2 years on this last incompetency finding. I've asked the state about plea offers. I sent them an email. It was probably the end of last week that I did so. I am hopeful that we can get a resolution here in the near future. So perhaps we put this on for a status in I guess we'll call it the next case management docket.
How about if I put it on either the June 10 or July 15 case management docket with the competency order in the interim?
Let's go with the June 10th one, Judge. And if we get a resolution, I'll get it in front of the court faster for a plea.
Any objection to June 10, 9 a.m. for case management?
No objection, Your Honor.
So ordered.
Thank you, Your Honor.
Mr. Ward, are you ready to call your case? I know Mr. Day is right, but you were actually waiting. Or do you want to pass, or do you want to address yours now?
I think mine's not till 10. I just
Okay.
came out because of the...
All right, then let me go ahead and address Mr. Day who's in person. We're having some trouble with Mr. Gorman remotely.
The Wi-Fi on the courthouse is cutting on and out.
Right. let's begin with the Hager case. This is a motion for evaluation from the defense, 21 CF 433, Mr. Day and Ms. Wilson. Mr. Day.
Your Honor, we have filed a motion asking the court to appoint a doctor to evaluate Mr. Hager for competency.
Any state comments?
Nothing from the state.
Taking a quick look at the motion. And there is a history of mental health issues according to the motion, plus what's been observed now. Motion is granted. We need to set a competency status review date.
Yes, sir, and I will send the appropriate order over to the court to fill in the blanks of what doctor you want for.
Is there any particular doctor that needs to be considered for this case?
I don't think so, Judge, and as I understand it now, I guess our list is dwindled again.
Right.
Seems to always happen, so I don't even know who's on the list.
Right, so we have Arias, McMurray, Collins, Nelson, so it doesn't particularly matter to either side?
Judge, I'm asking unless the state has an issue. Dr. McMurray, he's been very efficient lately, getting things back to us quickly.
Any state comment?
No, Your Honor.
I don't think he's on the list, Your Honor. I didn't think so either. I think he took himself off.
Oh, really? Sorry to hear that. He had been doing a lot of work.
He's been doing a great job.
Yeah.
Okay. Well,
all right, so we'll pick among the survivors.
Yes.
Okay. Ms. Wilson, any other comment?
No, Your Honor.
We set a competency status review date.
Judge Manalich's office.
Another competency status review date, Melissa, approximately 30 to 40 days out. This is the Hager case, 21 CF 433.
With July 12th at 9 o'clock work.
Any objections?
One moment, Your Honor. No objection, Your Honor.
It is set. Thank you. Next is Mary Touchard, Mr. Day, and Mr. Ashby. This is 20 CF 262. It's a motion for early termination of supervision. Does the state object?
Moment, Your Honor. Sorry. Did not have this on my docket.
Silence is acquiescence, isn't that really good?
Speak up or forever hold your peace, or be married.
Well, one moment, Your Honor.
What's that, Mr. Ashby?
I have one moment, Your Honor. This appears not to have made it onto my docket, so I did not prepare it. One moment.
I mean, unless it's some other assistant state attorney, you were listed, but.
Yes, no, that's not, it's oversight on my part.
One moment then. It was an original charge of resisting officer with violence.
But I have not contacted the officer. It does appear that she has passed the halfway point for her supervision. She received a
Is the defendant
12 months probation. It does appear she's gone at least the halfway point. There have been no violations that I believe I have observed in my quick view
something
here.
that you need to contact the victim officer about? And Ms. transferred to Hillsborough County? Yeah, she's apparently living in Hillsborough at this point.
Yes, Your Honor.
What's the state's request?
Your Honor, state this time would defer to the court. Just giving her the report once over here.
Okay, court will review the probable cause affidavit again. Apparently began as a Marchman Act.
Yes, Your Honor.
Several UFC type kick moves apparently administered. by the defendant. Don't see that there was any significant injury. Is the state deferring to the court?
Yes, they would defer to the court.
Motion is granted based on performance and no aggravated circumstances. Mr. Day to provide the order. All right. One moment. Mr. Day, you have another one. That one is Elkins 20 CF 1895. Motion to direct the electronic court reporting system to disclose a court-smart disk from an injunction hearing which you are claiming is related.
Correct, Your Honor.
Go ahead.
There was an injunction petition that is essentially mirrors the allegation in the criminal case where witnesses both testified. And as the court's aware, I can't have access to that information without a court order. So I just need a court order to be able to get the court smart disk from that witness testimony. And that's it.
So this injunction hearing discussed the events involved in the criminal case?
Correct. It was the same events they filed the petition for injunction and the criminal case. Both proceedings.
I believe that I previously denied a defense request for bond reduction in this case.
We have an emergency motion pending with the court on that ready here before the hearing day. Those misdemeanor charges tomorrow.
Okay, but I did deny it previously on this.
But
Okay.
we left the door open for us to
Understand.
go back.
All right. Only partially related to this as part of the history, but
Yes.
Mr. Ashby, any objection to this request?
No, Your Honor.
Is there any particular statute or other confidentiality provision which would prevent the court from overriding that?
There's nothing of a confidential nature in the proceedings around minors, allegations, sex offenses. The only issue is the general statute that doesn't allow people to get access to that court. There's no other confidential nature.
But obviously, in a criminal case where relevant, it should be the subject of a proper court order upon motion.
They are the same witnesses who testified to the same events in that proceeding. Testimony on the exact nature of our case under oath in the prior proceeding.
Does the state have any objections, restrictions, caveats, or not objecting at this time?
State wouldn't have objection to the defense getting a copy of the disc. We would have, like in the order that it not be disclosed, it be only be for the purpose of discovery. I assume that the state's assumption is that this is going to be used as basically a prior statement of the witnesses, and therefore used for impeachment or things of that nature at trial. So outside of those purposes, the state has no objection to the defense getting the disc, but for any other purpose, state would have an objection.
Mr. Day, is there any appropriate limiting language that would allow you to have, obviously I'm going to grant the motion, but would allow you to have the benefits of discovery and preparation and use in the criminal case, but not disseminate beyond those confines?
I have no objection to that.
Right. I'll ask the defense to provide an order reflecting the limits of the disclosure, that it can be obviously disclosed to defense counsel, but not to be disseminated. It may be discussed with the client, shown to the client, or shared with the client, but not to be published beyond that.
Yes, sir.
Unless within the criminal case.
I understand.
All right.
I'll prepare the order accordingly.
Very good. Next is Mr. Ward, State v. Garcia, 17 CF 2314, Ms. Mason for the state. This is a motion to early terminate supervision. Ms. Mason, what's the state's position? Let's see if we have Ms. Mason. I see her connected. I think she's trying to better connect.
Judge, are you able to hear me?
I'm able to hear you. We do not see you, but that's okay if we can hear you.
Okay, I apologize. It's a new computer and I don't know what's going on with it. Judge, the state does object on this case. There have been 2 violations of probation in this case. Yeah, there have been 2 violations of probation, so we're not in agreement with.
Ward, any argument?
Yes, Judge. First would be now well over halfway of this term of supervision.
So he's sentenced on January 30 of 18. Well, that will, where are we now? What's his end point?
Sure. At this point, he's terminating in August 14th of this year.
Even with the violations and the resentences?
Yes, sir. He's actually violated twice.
Right.
2 resentences in this case. But he scheduled to terminate in 3 months from now.
Okay.
I believe he is connected on the Zoom observing.
All right.
I would also point out that the defendant's probation officer in our last contact with her indicated that she has no objection that he has satisfied all conditions. And
What was the nature of the prior violations?
I think they were drug related, which is why it was changed to drug offender probation.
And he has been on drug offender probation ever since? The last violation?
Yes, Your Honor. I'm trying to look up the second violation, but my phone isn't ready. I know the first violation was for positive urinalysis for marijuana. But I'm not able to pull up an affidavit for the second. I would also note that, Your Honor, that the legislature has amended the 948 statute in the recent crime bill, and 948.04 subsection 4, really, it's not discretionary. It says, except as provided in subsection 5, for defendants sentenced to probation on or after October 1st, the court, upon motion by the probationer, shall either early terminate supervision or convert the term to administrative probation if all the following conditions are met. The probationer has completed half the term, which Mr. Garcia does, but he successfully completed all the conditions, which he has. The court has not found a probationer in violation of probation pursuant to a filed affidavit of violation of probation at any point during the current supervisory term. He's never violated this term of supervision. That early term was not negotiated, excluded by the plea agreement, and he's not a violent felony of special concern. Now, the court can get around this subsection by stating that it's necessary to keep the probationer on probation for the community protection or justice in the interest of justice. But after that finding, I think 948.04 subsection 4 requires the court to either early terminate or convert probation to administrative.
So, Ms. Mason, it looks like Mr. Ward did his homework and has called the court's attention to new legislation which appears to support his position. Any reaction?
Your Honor, I couldn't hear very much of what he said.
So to summarize, what's the statute section?
948.04 subsection 4 is fully quoted in my motion.
Okay, 948.04 subsection 4, where, to summarize, Mr. Ward is reading it to say that if the defendant meets the enumerated criteria, which are quoted, I think, in the motion, that unless community safety or the interest of justice require otherwise, the defendant is supposed to be allowed to early terminate if there's full compliance with the current term. And he's over half of the current term, right?
Yes, sir.
Any state response in return?
No, Your Honor.
I do notice that it was a robbery case that involved the physical taking against the will of the victim. The violations have been substance related, not new law violations, Mr. Ward.
Your Honor, I haven't been able to pull up for the most recent violation, but I don't believe so. There's been no new cases.
I've been able to pull them up. They are the most recent. Well, I apologize. I went back to a different case.
Yeah, the most recent one, Your Honor, he failed to attend the colorless drug testing call, meaning his color was called, and that.
He has not tested positive during the drug offender probation?
No, not.
Does the state believe that a no contact order or any other community safety issue is implicated by the request such that it should be denied.
Your Honor, there is a no contact order. I believe there's a no contact order that's in place. And I think the defendant is actually due to naturally expire in August of this year. So that no contact order. So it would be going away in the next couple of months anyway, but I think that it's based on the underlying charge. I think that it's important that the victim be able to benefit from, you know, the order that was entered against this defendant, that the victim's able to get the full term of that no contact order.
What does the state show as prior criminal history, if any, before this case?
If I can have just one moment, Your Honor, I'll have to pull that up.
Toward any other comments that would reduce the court's concern for the safety of the community or the no contact order issue?
No, Your Honor, just the email I quoted from the probation officer in the motion.
Which, again, the probation officer saying what?
The quote was, Mr. Garcia has successfully completed all conditions of supervision and has no violations. Mr. Garcia did comply with his monetary obligations. Mr. Garcia is eligible for early termination at this time.
I assume he had a substance abuse evaluation at some point. Were there any other special programs like anger management or anything like that that were ordered?
My internet actually, I think, just came back, Your Honor, so.
And Your Honor, as far as prior history, prior to this case, he only had a possession of marijuana.
Based on everything I've heard, then I will grant the motion. It looks like despite some relapses, the defendant has not had new law violations, has not posed a threat, and has complied, and probation indicates he is in compliance, and the new legislation would support his request. Motion granted, defense to provide the appropriate order. Okay. Next is State v. Neverill. Mr. Maresca for the state, Ms. Tyler for the defense, 20 CF 687. Motion to early terminate supervision. Does the state oppose?
Judge, we would leave it up to the court.
All right, Ms. Tyler, any comments?
I'll leave it at that, Your Honor. No, Your Honor, Mr. Neverill has been on for 2 misdemeanors. He has passed the halfway point. He has been compliant with all of his terms and conditions. He actually completed anger management well before he went on probation. We would simply ask that he be permitted to terminate as agreed upon at the time of the plea.
I do recall this case. I don't know why it was before me previously. Perhaps was it for an early termination previously or for some other reason?
No, Your Honor, just the original sentence. It was a felony reduction. But just then at the time of the plea, he would have been in front of Your Honor.
Okay. So this involved a neighborhood incident between Mr. Neverill and some minors. There were some aggravated facts. There doesn't appear to have been any significant injury inflicted on anyone.
Correct.
And he did do the anger management, is that correct?
Yes, Your Honor. And he really did engage for a long period of longer counseling. He was doing one-on-one counseling really since the time of the arrest, well through being on probation. I believe he actually still sees him, but I don't think it's as frequently as once a week.
The term of supervision was from November 3 of 20 for 1 year, I assume?
Yes, Your Honor.
So he's a little bit over halfway.
Yes, Your Honor.
There have been no violations, Mr. Maresca, that you're aware of?
Not that I'm aware of, Judge.
Okay. Did probation have any comment on this, Ms. Tyler?
We sent them our motion and notice of hearing, Your Honor, and I did not have any response from them.
Was there restitution paid or owed?
There was none owed, Your Honor. The restitution would have been for fishing poles that were actually returned within a few minutes of the actual incident.
And this is a withhold of adjudication on the original sentence. There was no part in the history of the sentence.
That's correct, Your Honor. Mr. Neverill is almost 80 years old.
Right. And did do the anger management.
Yes, Your Honor.
Any other state comment?
No, Judge, we would leave it up to the court. I think that we envisioned this when we did the original plea.
Okay, based on the circumstances of the original case, the state does not have any reason to believe that there are still tensions in the neighborhood that would be a problem without the no contact order.
As far as I know, I mean, since the plea, we haven't heard there's been any issues.
And I'm not,
Yep.
I apologize, sir. I don't even think, though, Your Honor, the juveniles live in that neighborhood.
All right. Well, I think Mr. Neville has addressed everything that was asked of him, and the motion is granted. Defense to submit an order.
Thank you, Your Honor.
Thank you, Judge.
Moving on. Next, we have State v. Posada, motion for early termination supervision. Mr. Calderon, Mr. Ashby, 20 CF 476. Does the state oppose?
No, Your Honor, no objection.
All right. Any
Judge.
Mr. Calderon, any clarifications?
No, Judge, I'm Mr. Posada sitting right next to me. He was placed on 18 months of concurrent probation on July 31st of last year. Was leaving the scene of an accident with injuries other than serious bodily and DUI with damage to person or property. He's completed all of the terms and conditions of his probation, satisfied all of his monetary obligations, and there's been no violations. And he's just about 10, excuse me?
All of the DUI-related conditions and the community service were done?
Yeah, that's my understanding. I talked to his probation officer, I want to say 2 weeks ago, and I also obviously talked to Mr. Posada, and here's everything's been completed and all of the financial obligations have been met as well.
And no restitution was ordered or owing?
There was $150 of restitution ordered, and it's been paid.
Did probation have any comment on the request?
Your Honor, I did speak with probation this morning, and they had no objection to the early termination.
Based on the performance by Mr. Posada and the rest of the comments, the motion is granted. Defense to provide an order.
Thank you, Judge. Have a great day.
Goodbye.
Bye-bye.
Pozo, 17 CF 57 and 689. Ms. Mason for the state, Mr. Verderamo for the defense, Mr. Carney appearing.
Correct, Judge.
The state opposed this motion?
Your Honor, I was actually looking into this as to the change in the law that Mr. Ward had previously brought up, because this defendant has had a violation in this case. But I'm checking to see if he's completed half of this term with no violations.
Any other comments, Mr. Carney?
No, Judge.
Now, there was a violation probation affidavit dated May 29th, 19 that was dismissed.
Yes, and I know there was a technical violation as well that Your Honor had they were told to continue supervising. So this would have been the one from, let's see here, 2018, and he was sentenced to 2 years of probation. So yeah, the state would have no objection, Your Honor. It appears that he's all paid up and has had no violations since during this period of probation.
Based on the evidence and comments presented, motion is granted. Defense to submit an order.
Thank you, Judge. Have a great day.
Thank you. State v. Rodriguez, Mr. Pica for the state, Mr. Hanukkah for the defense, 4 CF 3474 letter B, and Mr. Stublin, am I pronouncing that correctly?
Stublin,
sorry, for the state. This is here for competency status. Any update from either side?
Your Honor, yes, we've received the report. The report came back that the defendant was malingering. I have no request for additional evaluation.
I
asked the court. Well, I guess we need a hearing just to have the court accept the findings.
There is no additional evaluation requested by either side. Is that correct?
Correct.
Mr.
Correct.
Stubbs, the state request?
no.
So, Mr. Hanukkah, are you willing to allow the court to make a competency finding based on the report prepared without the need for testimony?
Yes, Your Honor. I was told we needed an in-person hearing, but that's.
Well, I can set it for a competency review, for a competency hearing, but will there be the need for testimony from any expert or any other evidence from your side?
No, Your Honor. No.
Okay. If the parties are willing to allow the court to enter a competency order based on the recommendation of the expert, Mr. Hanukkah, do you have an argument or evidence to dispute the recommendation of the report?
No, Your Honor. My only concern was, and this actually came up during the testimony in a previous sentencing at a concerns of the court. I've always been only able to communicate with my client through an interpreter. Never during my conversations did competency issues come up. However, I've always been kind of secondhand. I know that this doctor here during the evaluation, I thought she spoke Spanish because she never mentioned anything during the first time, but during the second evaluation, she used an interpreter. So I don't know if that affected her abilities to make a finding of anything like that. I guess I could talk to her to find out, but other than that, if
you wish to set it for a competency hearing with the doctor testifying so you can inquire on all these things? It seems as if you have some reservations.
I do, only because I thought she was going to engage him in Spanish. That was my only problem. Was that basically she's in the same, we're not in the same boat, but she's in the same position that I was in evaluating him. She's basically getting it secondhand, but she also had the benefit of the tests which were performed. So that's where I have my.
The defense is not asking for.
I'm not asking. No, I'm not.
So ultimately, the state, Mr. Stublin, is willing to allow the court to make a finding based on the report?
Yes, Your Honor.
As the defense, given that it has still some lingering concerns or reservations, the defense prefer to have a hearing with the expert testifying for a final decision before it is made?
I'm not, Your Honor. If like I said, the court had the ability to, I think if the court's going to be able to make that findings, I would rely on the doctor. But that was my only concern.
Do you have observations of the defendant that appear to be contradicting the recommendation or the finding?
No, Your Honor.
Again, I'm perfectly willing to set a hearing where the expert would have to testify and you could question her on any lingering concerns, or I can base it on the report.
I'm okay with it going on the report. I was just saying that was my concern. I don't know, because we came here because the court had concerns. I wasn't able to but I rely on the doctor.
What's the nature of the charge here?
Your Honor, this was a trafficking charge. It was a deferred, not a deferred prosecution. Well, a deferred sentencing based on a substantial assistance, and the defendant fled.
Who was the expert?
Taisha Nelson.
Nelson. At this point, given the significance of the charge and some of the concerns expressed about how the evaluation has been conducted, I probably would prefer to have the expert testify and set from court today a competency hearing with the expert testifying. Now, what I think I'll need to do is set it for a status only, because we're going to have to coordinate the expert to appear. Are the parties willing to have the expert appear remotely, or do you need to have the person, do you need to have it in person?
I don't have an objection to that.
The state's fine with them appearing remotely.
And are counsel okay appearing remotely also, both sides? We would need, are you waiving the appearance? I assume not, Mr. Hanukkah, if we're having the hearing. Is that correct?
I would prefer to have my client with me. That's one of my problems. I couldn't get into the jail. I don't know if things have changed since recent changes, but I have not been able to get into the jail to see my client.
I believe that if he needs to, Officer Capel is, Sergeant Capel is your contact at the jail, Mr. Hanukkah. She will facilitate within the confines of their policies for cases that need it. So you should contact her.
Yes, sir.
Let me set a status competency review date. In the meantime, I'll ask the defense to coordinate with Dr. Nelson and with the state for a hearing date with adequate time. I think the court would prefer to hear it from the doctor, answer the questions that have been raised, as well as observe the defendant at the hearing.
Yes, Your Honor.
So let me set a date now.
And there's also an ice
Yeah, law enforcement informs there's also an ICE hold in this case, and the
Yes.
file was left by the clerk. Hello, Melissa. We need a competent. Okay, I went through. Okay, what I can do, it's going to need to change anyway because we're going to actually have to get the doctor's availability. It's going to have to be set on a date when the defendant can be present. So that all has to be coordinated. But just for holding a spot here, I'm going to assign the case management date of June 10 at 1:30. Are both counsel available then? That's going to change anyway, but you can appear remotely for that. Any problem with that date?
I need 10 seconds, Your Honor.
Checking.
Yeah. He's there now? All right, one moment.
I have a video court date.
Judge Manalich's office.
Another competency status review date, Melissa. Now this one, what's going to happen is we just have to give it a placeholder date because this is going to require a competency hearing with testimony, and defense counsel, Mr. Hanukkah, will take the lead in coordinating with statewide prosecutor and with the court. The defendants in custody will need to appear for the hearing in person. So we're going to have to coordinate with the expert and the court facility availability for an in-person hearing.
Judge, if I may.
Yes.
I don't think we're going to be available on the 10th. If that's just going to be a placeholder date, then that's fine. But I think that Mr. Pica's going to have a conflict and I'm going to have a conflict as well.
I was going to put it on a case management date for on June 10 at 1:30 for just as a control date, but do you have another suggestion around that time? It's going to be canceled once Mr. Hanukkah coordinates with everyone for the actual hearing.
As long as that's going to happen, then we can, then the state's fine setting it there as long as we can get it off of that date before.
Melissa, is there any other date around that time that we could set it that wouldn't be conflict for them?
The June 7th at 9 o'clock.
Yeah, by then we can get it set for the appropriate date. How about June 7 at 9 a.m.? Is that any better for both sides?
That
I also have video court, but I'll work with it. I can appear in both places, Your Honor.
I think that would work for Mr. Pica.
They can appear remotely. It's going to be canceled once we get the actual hearing date. Defendant will need to be in person, Melissa, as opposed to by audio visual.
Oh, you mean for the status?
No, for the actual competency hearing.
Yes.
Now, are counsel going to be remote or in person for that?
For this,
It's
well,
probably better in person, but
I'll be in person. If it's the day that he's going to be there, I'll be in person.
Do you have any objection? The prosecution appears remotely.
I do not.
So I'll leave that up to the state.
Okay.
And we'll set Mr. Hanukkah, he'll take the lead in setting the actual hearing date.
Yes, Your Honor.
All right.
And which case is that?
This is Rodriguez 04 CF 3474.
Okay.
B.
It is set.
CFP.
Next, we have the 11 o'clock docket. Mr. Ashby and Mr. Viacava. I don't see Mr. Viacava at this point.
Your Honor.
And then, hello?
Hi, Your Honor. There is one case that I have actually spoken with Mr. Hollander about recalling. I know that he was going to come online, but his time was limited. It's going to be the Baker case. If Your Honor would be okay recalling that when he's available.
Yeah, I see him here.
Thank you.
Is it something I could stand in for?
Possibly. I can represent to the court that I spoke with Mr. Hollander as well as his assistant. Initially, I'd stated that Mr. Baker had not completed all the conditions of his probation, and that's correct. He still owes over $700 in fines and fees, as well as $1,300 in cost of investigation. They were under the impression, they said that they had spoken with the clerk's office, who told them that he has paid his half, which that's not the case. And the restitution and the cost of investigation were ordered joint and several with the co-defendant. So when speaking with Mr. Hollander as well as his assistant, I informed them that if he wants to early terminate his probation, he has to pay everything. He can't just pay half of it. They understood and they agreed. And so his assistant wasn't sure if she should just prepare an order denying the motion. I told her that I think it would be better to bring it back before the court so that it's on the record, and they agreed and said that Mr. Hollander would be back online.
So this was joint.
Can they withdraw the motion and reset it?
Well, I mean, I guess they could once everything is paid, but
right.
They're not able to. But as of right now, I know the court had previously granted it, and that's why we wanted to have it recalled.
So was joint and several liability for the amount, Ms. Mason?
Yes, Your Honor. So yeah, everything was ordered joint and several, and that's $1,374.50 cost of investigation, of which none has been paid. And this defendant still also owes $737.25 in fines and fees. So it appears that he did attempt to pay half of that. But I don't think they understood that he's got to pay all of it if he wants to early terminate. And I see Mr. Hollander present.
Not joined us. Mr. Hanukkah, you can bid adieu if you wish.
Thank you.
So, Mr. Hollander, there's still monies owing substantial that were joint and several ordered.
Well, if you look, it was joint and several on my guy, but the other guy it wasn't. I mean, he just hasn't paid. Oh, I'm sorry. My secretary says they were both joint and several. So
at this point, I believe that needs to be addressed.
All right.
Before this motion can be granted. At this point, the court will, I guess, Madam Clerk, does the clerk prefer that the court rescind its previous order, or is the clerk willing to have this motion withdrawn? I mean, it's been already entered or ruled on, so is it better for you to have the order rescinded?
I think it would be better if we had an order showing it.
Yeah, so the order would be rescinded based on clarification of some mistaken facts upon which it was entered. I'll ask Ms. Mason to prepare that.
Yes, Your Honor.
Well, it should also say that the motion may be reset. I don't think I need to have it refiled, just simply reset for hearing once the monetary amounts are satisfied in whatever manner, because it is joint and several. Mr. Hollander, any requested language in the order?
No, sir. It's just the other guy's half that didn't get paid. All right, we'll be in touch when it gets paid.
Does that language satisfy state and court concerns?
No, Your Honor. I think that language makes it very clear, and I will get that order prepared and I'll send it to Mr. Hollander to review prior to sending to your office.
Rescind the order based on a mistake of fact as to the joint and several liability. However, the motion may be reset upon the joint and several liability being addressed in any satisfactory manner.
All right, Judge.
it could be that one guy pays all or they pay in some share, but as long as it all gets taken care of, whatever way it is.
I understand. That appears to be what's going to happen. So
Okay,
I'll pass the good news on to my client.
very good.
Thank you.
Okay. Let me take a look here. 11 a.m. We have Otero, which is Mr. Viacava. I don't see anybody appearing yet. We also have Ortiz, which is Ms. Marzano, and defense counsel from out of county, not listed, but I can't remember the name. Doherty, Mr. Doherty. So I don't see them yet. Is there anything else, Ms. Wilson, Ms. Mason, or Mr. Ashby that I need to address right now before the break?
Nothing that I'm aware of, Your Honor.
No, Your Honor. The Miranda Otero case was scheduled for 11, so I expect Mr. Viacava to join us at that time.
Right. So at this point, we'll just have to wait till 11. Okay. Goodbye.
Thank you, Your Honor.
We'll just mute for the time being. that. This is the Otero case 20 CF 223. Can everyone hear me?
Yes, Your Honor.
Yes, Your Honor.
All right, very well. Mr. Ashby, does the state oppose this motion to take depositions in a driving related case?
Yes, Your Honor, the state does.
Ms. Augustine.
Your Honor, we filed a motion to take depositions in the case of Xavier Otero, aka Juan Vega, and 20 CF 223. We're asking to depose a total of 4 witnesses, which are all of the witnesses in the case, 1 civilian witness and 3 law enforcement officers. Our client is charged with unlawful possession of a license, a 3rd-degree felony, DUI 2nd offense, driving while license suspended 1st offense, and giving a false name. The depositions will protect his rights under the Confrontation Clause and enable the defense to adequately prepare for trial. We are asking for a total of 2 hours to take the depositions via Zoom, which we would argue is a limited amount of time for the defendant to receive this additional discovery and will be convenient for the witnesses and the prosecution. Trooper Halligan was the arresting officer and also conducted the traffic stop, but it's unclear in the discovery, the written discovery, if the caller or callers identified themselves. He mentions that the callers complained of the same driving pattern, but what pattern were they complaining about? There is dash cam video, but it's unclear if the trooper observed our client driving and that driving is not on the dash cam video. That goes to the heart of whether there's a motion to suppress and a defense at trial with respect to the charges. He also mentions that our client ran off the roadway onto the shoulder, and according to the case law, it matters whether our client's driving affected any other drivers. To what degree did the vehicle cross over the center lane? Although I can see on the dash cam video, there are drivers ahead of our client. They're far ahead of our client. I can't see any drivers to the left or right of our client, but how many drivers other than the officer were behind our client? We need to know that to know whether we have a good faith basis to proceed with a motion to suppress. There are 2 other troopers, Trooper Duzgan and Trooper Gibbs. They did not write any statements. To the best of my knowledge, they were not wearing body cam. Trooper Halligan, the arresting officer, put in his report that their reporting role was other for both of those officers. So we have absolutely no idea what their involvement was in the case. What did they observe our client doing, if anything? Did they observe the field sobriety test? Did they observe our client driving? Did they speak to our client? Did they ascertain whether he smelled like alcohol? There are so many questions for those 2 officers because their reporting role is other, no statement. Finally, we're requesting the deposition of James Moynihan, who is a civilian witness. He wrote a statement, but it only consists of 5 sentences. Again, we need to know, was this an anonymous tip? That goes to a heart of a motion to suppress because, of course, the arresting officer, if he was going off an anonymous tip, Officer Halligan would need to have some independent corroboration of criminal activity. So we need to know, did he provide his name? Did he give a license tag number? Also, deposing that witness goes to whether Mr. Moynihan would be a witness at trial. Did he speak to our client? Was he within a close distance of our client? Did he observe any field sobriety tests? That is unknown in his 5-sentence statement. So we are respectfully requesting to be allowed a total of 2 hours via Zoom to depose these 4 witnesses.
Mr. Ashby?
Taking the witnesses in order, starting with Trooper Hooligan. The officer wrote an extensive report. It's approximately 8 pages in length. In that report, he details in great detail his involvement, what he did on the stop, and the basis for the stop. Appears the defense is essentially seeking to depose the Trooper Hooligan to file what is known as a crux motion. As the officer stated here, the defendant drove off the roadway on 4 different occasions. The officer observed him driving around the curb, and the vehicle was traveling in the center of the roadway, straddling both lanes. Based on that alone, that gives the officer basis to make a stop. We're not here to argue the motion express. We're simply here to argue whether he should be deposed. An officer who's written an 8-page report in this case, the state's opinion has provided a full information as to what his involvement, his role, and what was done in this case as far as he is concerned. So the state believes there's...
On that point, I agree with you that the officer did put significant detail into his report. I only show it's 2 pages. It does contain significant detail, but I only show 2 pages of narrative. You're referring to 8 pages. What are you referring to?
I'm referring to his full report. There is the booking sheet, which I believe is what you say is only 2 pages. Then there is the full report that the officer submits, which is basically the DUI investigation case report. That is significantly more pages. There's the 4 pages for the booking report, 2 of which are just our narrative, and then there are the rest of the rest of the report. All that has been provided in discovery. That is state's discovery 1 through 32, which is going to be including that booking report as well as the officer's full report. So he provided all of that information as to what his involvement is and what his investigation entailed. As it pertains to the other trooper officers, it appears that they were there simply for scene security. As mentioned by defense, there is a video in the case which shows the entirety of the interaction between the officers and the defendant. Viewing the videos, you can tell what involvement, if any, the other officers had with the defendant, and if any of it is relevant to this case. Again, taking the discovery as it is right now, there's no big reason to depose those 2 officers. Lastly, the civilian witness did write a statement in this case. And most notably, defense mentions that they want to, in their motion, they mentioned they want to depose him to see if he was the one that called 911 or called the troopers or called the police to report the defendant's driving pattern. The state, looking at the profit to the court, that in the witness's own report, it states he called star 347 to report the driver. So clearly in the statement, he mentioned that he was the one that called. And he gave a full statement as well as to the observations that he made about the driving pattern of the defendant. So at this point, the state believes there's no basis for the depositions to be taken. The parties have the discovery is full in what has been provided, and there's no need for depositions in this case.
Any rebuttal, Ms. Augustine?
Yes, Your Honor. With respect to Mr. Moynihan, the civilian witness, my motion doesn't state that I need to find out if he called the police. Rather, it says the defense needs to depose this witness in order to ascertain if he gave his name when he called the police, how detailed his description was of the Jeep, did he provide the license tag number, and also to ascertain if he's going to testify with regard to any of the charges. Did he speak to our client? Was he within his presence? Did he observe his performance on the field sobriety exercises? Your Honor, with respect to Troopers Duskin and Gibbs, Trooper Hulligan says their reporting role is other. That does not state what they observed with respect to a driving pattern, communications with our client, or whether they smelled alcohol on him or heard any statements with respect to a false identification. With respect to Officer Hulligan.
Before you move on, Mr. Ashby said as to those two that they were scene security and that the dash cam video is self-explanatory as to what role they had. Why is that not sufficient?
Your Honor, I don't know if they saw the driving pattern, and he's saying they're scene security. I read Trooper Hulligan said reporting role other. It doesn't say scene security in the discovery. It says other.
And lastly?
And lastly, Your Honor, with respect to Trooper Hulligan, I agree. He wrote an extensive report, but with respect to the motion to suppress, it is unclear if this was an anonymous tip or if he knew the identity of the caller. And in his report, he says there was a bolo, but he doesn't state if he knew the identity of the caller. And the beginning of the dash cam video showing the Jeep that our client was driving is very blurry. And we need to know any driving he observed that's not on the dash cam. And again, the Crooks motion, Crooks v. State, 2nd DCA 1998, that goes to whether the officer felt there was a reasonable safety concern. We don't see traffic on the body-worn camera in front of our client to the sides, but how many vehicles were behind our client other than the officer? That's unclear. That's unclear in the discovery and the video. And we need to know if anyone behind our client that his driving posed a reasonable safety concern to those drivers, if any.
Anything else?
No, Your Honor.
State's only would again point to the officer's extensive report as to the numerous violations that he observed while driving. In his report stating the numerous observations that he made.
The standard in this type of case is whether the defense has shown good cause. With regard to Trooper Hulligan, it is true he wrote a relatively detailed report. It is contained in about, looks like about a page and a half. I do think the defense has raised some unanswered questions that may be relevant. And with regard to the others, it's simply referred to as other. They may or may not have had a role, but I think the defense should be allowed to inquire. They were part of the whole event. And lastly, 5 sentences from the witness, I think, is not sufficient to fully develop what that witness's role was. So I will grant the defense motion to take the discovery depositions on all of them. Granted.
Yes.
All right. Any other
Do you want us?
defense to provide an order, please?
Yes. Thank you, Your Honor. We will. May I be excused?
Yes. Next is State v. Ortiz, 21 CF 418. Ms. Marzano for the state, Mr. Doherty for the defense. Are you both connected and able to hear me?
I am, and I can.
Greetings, Ms. Marzano. She was there before, and I see the box, but has not yet connected, is muted currently. Wait a moment. Ms. Marzano, are you out there? You'll need to unmute.
Get unmuted. I'm unmuted now.
All right, very good. All right. I have called the Ortiz case. This is the state motion to subpoena defendant medical records from a certain time frame, as well as for permission to talk to emergency treatment providers. Mr. Doherty, does the defense oppose this motion?
It does.
Yes?
Yes.
Okay. Ms. Marzano, argument?
Well, my argument is, Your Honor, these records are relevant. Both the victim and the defendant had gunshot wounds in this incident that occurred. It's recorded on video. I believe it will be argued. There may be arguments of self-defense, et cetera, that come up during this case by the defense, and where Mr. Ortiz had injuries and what kind of injuries they were, et cetera, is entirely relevant to the case in which Mr. Ortiz has already been charged with second-degree murder with a firearm. So I don't see, and we're limiting it to this 2-day period in which he was treated for treatment of the injuries that he had. So I don't think we have to establish much more than relevancy in order to get all of these records for a limited period in regard to the treatment he received for these gunshot wounds.
Mr. Doherty?
Yes, as stated in my motion, my main argument is that her request is overly broad and not narrow enough in scope as to what medical records and for what theory Ms. Marzano would need those for. Her motion asks for all medical records. I believe that's overly broad, according to State v. Severus. There's two issues that I have with Ms. Marzano's motion. One is requesting records and statements, which I'm going to address here, and then second, the future communications with Mr. Ortiz's medical personnel. As to his records and statement, Ms. Marzano basically is saying that he was charged with, Mr. Ortiz was charged with second-degree murder, therefore they should have all medical records, and without stating the nexus of how his injury will promote her theory of second-degree murder. Her request is more akin to a warrant. It's very broad for all medical records and all statements, communications, so on and so forth between Mr. Ortiz with his medical personnel. If we look to, I did email some case law earlier. The first case I'm gonna look to is Lecca v. State. And I'm looking at page 4 of the PDF, which is actually page 859 of the case. And it says the cases have required that the state show a nexus between the medical records the state seeks.
I'm sorry, which case are you referring to, sir?
Lecca v. State, 283 Southern 3rd, 853.
I apologize for interrupting. Go ahead. Sorry.
I'm actually on page 4 of the PDF.
I am there.
Okay. The case required that the state show a nexus between the medical records the state seeks and some material issue in the case. One, by identifying some theory that reasonably makes the records relevant, and two, producing some evidence that makes it reasonable to expect that the records will produce evidence that supports the theory. And so far, Ms. Marzano hasn't presented any evidence here at the hearing. On the next page, on the left-hand side of the page, the Lecca court is quoting Faber, and it says there's nothing in the record indicating the scope of the records requested or that those records would be examined in camera by the trial court. That's what we're requesting, is that the state limit their scope. That's why we did our motion to strike. They're overly broad and not limited in scope. Now, if we go to the next case, which is Gomillion v. State, And I'm looking also at page 4 of the PDF, page 507 of that case. And that case is quoting Rivers, where it says that the state's burden was satisfied when the materials were directly related to the offense, which the defendant was charged. In this particular case, his injuries aren't directly related to second-degree murder. Again, it says identifying some theory that the state needs to identify some theory that reasonably makes the records relevant and producing some evidence that makes it reasonable to expect that the records will produce evidence that supports that theory. Now, based on Lecca, Gamillion, and Severus, the defense is stating that the state's motion, again, is overly broad, as well as not limited in scope enough. Of what records does she want? Does she want a lot of these cases come from DUI cases where the only records they get would be relevant to either drug and alcohol, and that would be all they would get. Here they're asking for all his medical records. In some of the cases that the state has stated, most of those, the records were not seen as confidential because they were based on illegal and fraudulent prescriptions. Here we don't have an illegal or fraudulent prescription case, and it's not a DUI case, and it just seems like it's more of a fishing expedition rather than a narrowed in scope subpoena.
All right, thank you, Mr. Doctor. Rebuttal, Ms. Marzano?
Well, first of all, Your Honor, let's take a look at the Gamillion case, and what you'll see that is notably distinguishable is the fact that in that case, the defendant had not been charged with a crime involving these records that were being set yet, and it was just a criminal investigation that was ongoing. And in that case, the state indicated that the state wanted those records for possible impeachment. I am not looking at these records as a possible impeachment, and the defendant in this case is charged with second-degree murder with a firearm in an incident in which he was shot as well as the victim. And those records are going to be extraordinarily relevant because the defense is likely to raise self-defense as a possible defense in this case. Then if you go to Lecca, again, it is a case in which the state had not yet charged anyone with a crime. So, you know, they were saying there's no crime that's been charged. These are overly broad because we don't know, you know, it's there. They don't really, there was no crime charged. It was an investigation only in Lecca, and that's what Lecca turns on. In regard to Severus, that was a case that involved, hold on 1 second, Your Honor, I have it on the computer, so I have to get to the beginning of it. That was another case where, and it involved a statement that it isn't medical records that they were seeking. It was some type of statement. And so it really isn't, it isn't apples to apples here. They were trying to subpoena records of a statement that was taken by a medical examiner, I believe, although, and it really, it's just not, it just doesn't transfer factually to what we have here. In this case, I have asked for specific records of his treatment following this shooting from NCH, where they took him initially, Lee Air Flight, where they flew him to the hospital, and at Lee Memorial Hospital. And I have sought to be able to discuss the medical records that I obtained through a court order with the medical providers, because if I don't ask for that, then I have the medical records, and then the doctors won't talk to us about what's in them. And if we get them and we want to use them, you know, obviously I need to be able to communicate with the medical professionals. I haven't asked for any records before this or after this. I don't need those. I need records from the treatment, specific treatment. It will be relevant to possible angles of, you know, gunshots, identifying where he was injured will be very important in establishing what occurred in this case. All of those things. So it is not overly broad what I've requested, and it is relevant. And if there are any matters that are not relevant, you know, counsel has the ability to ask the court to, you know, exclude certain portions of the medical records. But until I can see them, you know, it's not possible to know whether or not they have things in them that the court might not allow it. But, you know, it's not going to violate, and all we have to prove is a nexus, which clearly there is one here, that these are relevant, which clearly they are. And in this case, our defendant has been charged with a crime already. So it's not just an investigation.
With regard to the nexus, and you alluded to this, but more specifically, what's the nexus of these treatment records to the second-degree murder charge specifically?
They're going to establish information that will be necessary in order to deal with any type of possible defenses, such as self-defense. And
elements of the offense?
I'm sorry, what, Your Honor?
Do these records potentially, do they have a nexus to the elements of second-degree murder, or is it more in response to an anticipated self-defense?
I would say more as to a possible self-defense argument. I mean, obviously, you know, it's going to be difficult to analyze exactly what's occurred without knowing where his injuries were. Clearly, it appears that there were 2 guns being fired, and when and how and where his injuries are significantly important in regard to proving this case. And I believe there actually would be the ability to obtain a search warrant. I think there's probable cause for these records.
Regard to the overbreadth and scope arguments.
Yes, sir.
Mr. Doherty was saying that the problem there in part is that you're requesting all records.
Yes.
In response to that, as to why that all records is not overbroad or too broad a scope.
Because, Your Honor, in that 2-day period where he was treated, he was being treated specifically for these gunshot wounds and nothing more. We have limited it in scope to the 2 days following the shooting. You know, we're not asking for follow-up care that he had with anyone, because that really isn't relevant. And I don't really want to know about that. I want to know about what treatment was required for him in this period of time following this shooting incident.
And lastly, with regard to the request for in-camera review, what's your response to that?
Well, Your Honor, I don't see the need for it, because obviously, you know, there is the ability for Mr. Dougherty at a later time to come in and request that the court exclude portions of the record. I mean, Your Honor, I mean, respectfully, I know Your Honor could review them, but I don't know that, I mean, you don't have all of the discovery and the information that we currently have. I mean, and in this case, I have the victim's autopsy, you know, report coming if I don't have it already. I mean, we're going to have the victim's records, which are hugely significant. I don't think Your Honor could say that in a shooting where the victim gets shot that the autopsy records would not be relevant. These are really no different than those, because these are for treatment from this specific incident. So the autopsy is really no different than the medical records of the defendant in this case, because they both were shot in this incident for which the defendant has been charged with a crime. So, I mean, while if Your Honor chooses to review them in camera, that's fine. But I fear that the problem is that Your Honor doesn't have at this time access to all the information that the attorneys in this case have.
Mr. Dougherty, any final comments?
I do have some final comments. As far as an autopsy goes, a deceased victim goes to the element of murder. Treatment of my client does not prove the element of murder or go to the element of murder. It's more of an investigatory tactic that I'd like to call a fishing expedition. That's really what their purpose is to continue investigating all of his medical records, which are first and foremost highly confidential. Once they're disclosed, they are no longer confidential, and he lost his right to confidentiality. That's his constitutional right. Once they're disclosed, there's no redress. That's why should you issue a subpoena, I'd like you to review them in camera for whether they're relevant or not. Ms. Marzano did say earlier about shooting angles. She was discussing shooting angles. Now, shooting angles could be relevant, but not all medical records for all of his injuries and all of his treatment. If she could get medical records just showing the angles of the bullet wound, that would be limited in scope, more proper for subpoena ducis tecum. When I originally, I did not the future communications with medical personnel. I adopted Ms. Marzano's witness list and disclosed it to her today so that they are my witnesses as well. To prevent, I'm not saying Ms. Marzano is going to coach anyone, but prevent any investigators or actors on the state's behalf from coaching witnesses before I can speak to the witnesses.
I'm sorry, Your Honor.
Excuse me, I'm still speaking, Ms. Marzano. The best way to do this, where I have a chance to ask questions and Ms. Marzano has a chance to ask questions, I think the proper venue would be through deposition.
Your Honor, any party can discuss with a witness information. You don't have to take a deposition. We don't have to take a deposition of our own witnesses. If I wanted to talk to one of my witnesses, I can do that. But I'm sorry, Your Honor, the suggestion that I would coach a witness, I take great offense to that. That is not a very professional way of handling something. First of all, I would never do that. And secondly, it's just uncalled for.
Interrupting, but I think Mr. Doherty said that he was not suggesting that as to you. I thought him saying that he was just concerned whether any investigative staff might cross a line.
Your Honor, my investigation.
Even inadvertent coaching, and that's what I really meant was inadvertent coaching. And I do.
Well,
I take offense to that, Your Honor, whether or not however he meant it. My office, myself, none of us would ever do that.
Well, again, the comment I heard from Mr. Doherty is primarily, as I understood it, directed toward whether intentional or unintentional by any law enforcement investigative agency. But regardless, obviously this involves constitutional rights of privacy and medical records. For that reason, we have the case law that has been cited by both sides. The state correctly observes that the cases mentioned, Hunter, Rivers, and McElvey, which are cited in the state's motion, do give a broad right of access, provided that, as Mr. Doherty said, the scope and the nexus elements are shown. I believe in listening to the state's argument about the facts alleged and anticipated to potentially be involved, not only in the charge, but any potential defenses which might naturally flow from that, are such that the limited time span of records for the 2 days of treatment and interaction with the medical professionals about the services rendered during that time frame only satisfy the case law requirements, with the case already having been charged. I do not believe the case law would require at this point in-camera review. There may be other remedies available to the defense if it believes that at trial that would be inappropriate use of any evidence that was disclosed. So I will grant the state's motion as presented with the limitations for the two-day treatment records, as well as the interviews of any related medical personnel mentioned to be limited to the treatment provided during that time frame.
Yes, sir.
Any
I'll
other-
provide an order.
Any other clarifications?
No, sir. Thank you.
Nothing from the defense.
All right, Ms. Marzano, prepare the order in accordance with the oral ruling.
Yes, sir.
All right, thank you.
Very much.
Thank you. Have a good afternoon, everyone.
All right. I'll just shut down.